How many holders support Ripple? When will the SEC listen to reason? Will XRP cost $2? We will answer all these questions in today's video. Wally thinks Ripple's case against the Securities and Exchange Commission will be resolved in favor of the XRP progenitor, prominent crypto supporter John E. Deaton has hinted at what may happen if the securities watchdog wins. Is Ripple capable of defeating the SEC? Ripple has won multiple procedural wins, leading XRP supporters to anticipate that Ripple will win the 2-year court fight. Nevertheless, if things don't go as planned and presiding Judge Annalisa Torres believes the SEC's claim that all XRP transactions, including those done on secondary markets, are securities, the Commission's triumph may mean difficulties for many other crypto-focused businesses. According to John Deaton, this is the case. Deaton stated that a favorable verdict for the SEC would provide its chair, Gary Gensler, the necessary cover as well as the impetus to file similar claims against corporations operating in the digital asset market. The XRP lawyer's remarks were in reaction to a tweet from Fox Business writer Eleanor Terrett, who revealed some details concerning the recent closure of Signature Bank. Significantly, no reason was provided when the New York Department of Financial Services announced the closure of Signature on Sunday. Terrett referenced former Congressman Barney Frank, who pointed out that sending an anti-crypto message was a planned act. Ripple is a cryptocurrency industry behemoth in the United States, developing real-world goods based on breakthrough technology. In December 2020, the SEC threw a bombshell on the burgeoning industry by suing the business and 2 of its senior executives for illegally generating over $1.03 billion via the sale and distribution of the XRP cryptocurrency. The primary issue in the case is whether XRP is a security, and the outcome of the court hearing will decide the token's destiny. Most crypto commentators feel that Ripple has the upper hand in the long-running legal dispute. Nonetheless, the SEC suffered a defeat last month when the court declined to dismiss Ripple's essential fair notice argument. The judge's verdict, which is anticipated in June, will almost certainly be a watershed moment for XRP and the larger crypto market. Yet, if Ripple wins, XRP might make a run towards $1. According to attorney John E. Deaton, the United States Securities and Exchange Commission, SEC, action against Ripple might reach the United States Supreme Court before Congress adopts a regulatory framework for the crypto business. For perspective, the matter is now in district court and would need to be heard by the Circuit Court of Appeals before being heard by the Supreme Court. In a tweet today, the cryptolaw creator stated this viewpoint that followed hints that the SEC had no intentions to slow down its aggressive crypto enforcement activities. Fox Business writer Eleanor Terrett published an extract from the SEC's current budget plan. Significantly, the government adds that it will not hesitate to investigate and prosecute crypto businesses that it considers non-compliant. This, according to Terrett, signals that the regulator would increase its crypto enforcement section, which has more than quadrupled in size in the last year. Citing Terrett's conclusions, Deaton reiterates that the courts will be the sole source of clarification for crypto for the next 2 years. Although he acknowledges that it is not ideal, he insists that it is the current reality. Hell, before Congress acts, the Ripple case might be heard by the Supreme Court. Deaton tweeted, "We have to battle in court." In January, Deaton said that the highly awaited verdict in the Ripple case on whether XRP is an unregistered securities would provide the embryonic market with the only clarification it would get in the next 2 years. The lawyer presented this case by highlighting the polarization of Congress and the bitter taste the FEC's failure has left in MPS's mouths. Yesterday, the attorney representing thousands of XRP investors in the SEC complaint against Ripple as a friend of the court said that Judge Annalisa Torres' approaching judgment becomes more momentous with each passing day. He did, however, express confidence that the federal court will rule that secondary market transactions of XRP are unregistered securities. There is no precedence, according to Deaton, and Judge Torres is a stickler about obeying the law. There is no way the court will accept the SEC's unlawful premise that the asset itself is always an investment contract, Deaton said on Twitter. There hasn't been a case in the 80 years since Howard that makes such a conclusion. Judge Torres strictly adheres to the law. She refuses to find that secondary sales violate Section 5. According to Deaton, the only way the SEC can win its case against Ripple is if the blockchain payments company offered XRP as a security from 2013 to 2017. Judge Torres issued her decision on Daubert requests to prohibit expert evidence last week. It was largely seen as a Ripple success, with Ripple General Counsel Stuart Alderati claiming that the firm's confidence improves with each verdict. Deaton anticipates that the judge's decision on summary judgment will be issued shortly. If Ripple prevails in its legal fight with the U.S. Securities and Exchange Commission, SEC, the relisting of the XRP token on the main U.S. crypto exchange Coinbase will be one of the greatest headlines in the XRP ecosystem. In a recent interview, Coinbase's chief legal officer, Paul Grewal, has talked in depth about the matter and outlined how the XRP relisting process would work. Coinbase banned XRP trading in January 2021, soon after the SEC filed its complaint, and has since kept the coin suspended despite vociferous XRP community requests. Grewal stated his hope for a Ripple triumph in yesterday's discussion with Thinking Crypto presenter Tony Edward, but also highlighted that a relisting does not rely entirely on a trial court success. Grewal said that the U.S. crypto exchange assesses assets on a regular basis for listing, delisting, or halting. He also understands the XRP community's angst. I realize it has been irritating for many XRP holders that they have not been able to trade their assets on Coinbase while this SEC action has been ongoing, Grewal said, adding that the SEC has not prevented Coinbase from closely monitoring the state of the dispute. Grewal, like everyone else, is looking forward to the judgment and lauding Ripple's attorneys' efforts. I definitely paid attention to the fact that the defendants in this case have done a fantastic job of pushing the SEC and raising fundamental concerns about the SEC's overall argument. Coinbase has filed an amicus brief in favor of some of Ripple's arguments. According to Grewal, Ripple's CEO Stuart Alderati and the rest of the fintech business have done an amazing job, which is why he believes the court will rule in Ripple's favor. Will show that the SEC ideas are flawed. I believe the briefing in this case has been outstanding, and we will all soon see what the trial judges think of the arguments. Nonetheless, the Coinbase CLO emphasized that, in his judgment, the Southern District Court of New York's ruling is merely the first stage in a prolonged process. Grewal feels that regardless matter who wins in court, both parties in the case will appeal. Grewal added that the timing for relisting following the trial court judgment relies on the reasons of the judgment, the judge's legal rationale, and Coinbase's opinion of whether or not the decision would be upheld by the appeals court. Therefore, a lot is going to rely on the particulars of that court rulings. I realize it won't be very pleasing for some, but as a publicly traded firm, we have a duty to tread cautiously in this area, and with regard to any token that's the subject of federal court action, Grewal said. Finally, the Coinbase CLO said that the exchange would begin the review process as soon as the judgment is published. So, like everyone else, I am curious to see how the court decides, and all I can say is that as soon as we obtain the verdict, we will begin our process to see if we need to reconsider our listing decision.